President of Nagorno-Karabakh can be issued with a passport of the Republic of Armenia? And do you have any figures how many of them have been issued with it? My second question may be not too much related to today's deliberation because as court decided in his admissibility decision, we will be considering facts after ratification of convention. But in any way, what would be your comments on the statement of Vazgen Manukyan, who was Armenian defense minister in October 1992 and who made statement in 2000 about Union of Armies NKR and Armenia, which is mentioned in the book Thomas de Waal, Black Garden, referred by applicants. And also, more concrete question, could you explain how it was possible that the Armenian law enforcement agents operated in the case of Zalyan and others in Nagorno-Karabakh and the Syunik Regional Court of Armenia hold the hearing in Stepanakert? And my last question, could you please compare the financial support which Nagorno-Karabakh gets from all Armenian fund and from other sources, namely from the government of the United States? Thank you.
Thank you, Judge Giuliani. Judge Spano.
Thank you, Mr. President. I have one question for the applicants, and third-party interveners may respond if they so choose. The applicant's counsel cited paragraph 56 of this court's judgment in Loazido versus Turkey in support of the submission that the effective control test does not necessitate a demonstration of detailed control over the policies and actions of local authorities in the disputed area. In paragraph 56 of Loazido, the court stated, and I quote, "It is not necessary to determine whether, as the applicant and the government of Cyprus have suggested, Turkey actually exercises detailed control over the policies and actions of the authorities of the Tiran Sea. It is obvious from the large number of troops engaged in active duties in northern Cyprus that her army exercises effective control over that part of the island. Such control, according to the relevant test and in the circumstances of the case, entails her responsibilities for the policies and actions of the Tiran Sea." In Al-Skani, the court elaborated further, stating that the factual assessment of jurisdiction must be, and I quote from paragraphs 138 to 139, primarily based on the strength of the military's presence, as mentioned by counsel to the third-party intervener. My question on this basis is, I would kindly ask the applicants to explain as concretely as possible what they consider to be their strongest pieces of evidence from which the court would be able to draw sufficiently strong, clear, and concordant inferences as to the respondent government's strength of its military presence in Nagorno-Karabakh in general and in Lachin in particular. Thank you.
Thank you. We will have now a 20 minutes break, and the court will resume. We will resume the hearing at around 11:25.
La Cour.
please be seated. I will give the floor to the lawyers acting on behalf of the applicants and to the lawyers acting on behalf of the respondent government. Who wants to take the floor on behalf of the applicants? Mr. Müller.
Mr. President,
Please.
Perhaps I can start with the learned Armenian judge's question concerning the alleged ignorance of the lawyers, the applicant's lawyers, and my learned friend Mr. Robertson's claim about the lawyers' failure to go to the Armenian Republic to lodge claims. Mr. Robertson is kind enough to submit that we all belong to a very experienced non-governmental organisation, and yet at the same time he claims that we simply fail to bother to explore domestic remedies in Armenia. That, with respect, is not the position. Neither is it the position that we are ignorant of Armenia and its jurisdiction. I, myself, have appeared in a number of cases before this court in relation to Armenia, including cases such as Meltex. The reason why, in actual fact, no remedies were exhausted in relation to this case was because we took the view, having regard to all the evidence in this case, that no remedies were identifiable whatsoever, and certainly not effective. And so perhaps I can begin my address by referring to the very paragraph that my learned friend Mr. Robertson referred to in suggesting somehow that the position of the lawyers in this case was simply not to explore domestic remedies as a consequence of ignorance. In fact, paragraph 151 reads as follows at the end: "They agreed to act in ECHR-related proceedings after a view had been taken as to whether Article 35 requirements concerning the exhaustion of domestic remedies had been satisfied or not. The view arrived at, for the reasons cited in these submissions, was that there were no identifiable, let alone effective, domestic remedies available, capable of offering redress for the complaints raised with any prospect of reasonable success." That is the position of the applicants. It has absolutely nothing to do with the ignorance of the lawyers representing the applicants, or indeed their reluctance to travel to Armenia. It is also the consistent position as expressed in all the written pleadings for the last 7 years. So we say that allegation is both misleading. I would also add that many of these lawyers are extremely experienced in relation to the issue of exhaustion of domestic remedies. Myself, together with many others, were involved in the case of Activar and fully understand the obligations to exhaust domestic remedies. And it may well be prudent to read the statement of Katrina Vine in relation to the exhaustion of domestic remedies and also the position of the NGO. Now, as to the suggestion that the courts, judges and lawyers of Armenia are waiting to process the case and want to be given an opportunity to show that they can give justice for the applicant, perhaps I can just refer to one or two of our submissions in relation to the position of Armenia, and by way of this answer the learned judge's question from Armenia concerning the readiness of judges to deal with these issues. First of all, I refer to Annex 1 of Mrs. Vine's statement, in which she makes clear that her attempt to try and make further inquiries of other individuals who might be willing to assist in this case ran into severe problems for fear of being identified by the Armenian government as being involved in these proceedings. This reticence to become involved in the case in any way by such a wide range of suitable qualified experts is a poignant reminder of the insidious undercurrent of discrimination by the Armenian government officials against anyone choosing to be affiliated in any form with the applicant's cause of returning to their homeland. And I would also point the Court to the statement of the UN Special Rapporteur concerning the role of the human rights defender, because that also gives flavour to the present position in respect of cases such as this. Those could be found at paragraph 138 of our written submissions of 2013. In particular, he quotes, "The Special Rapporteur is disturbed regarding reports of violence against human rights defenders, in particular journalists, and of the failure to fully and thoroughly investigate and prosecute such incidences." And I also refer to the American Bar Association that did extensive research over the many years concerning judicial reform and the independence of the judiciary, where it refers to a persistent problem concerning the independence of the judiciary. I don't propose to give any evidence in this case as to whether or not judges who have filed evidence in this case are lying or not. It is a matter of weight and relevance for this Court. This Court can well judge whether or not witness statements are supported by the facts on the ground in this case, and indeed whether or not they come from a party pre-party. Just in relation to my learned friend's submissions concerning the time as to when to judge the issue of exhaustion, we say nothing should depart from the normal rule that is when the application was lodged. And I would once again refer the Court to the question posed in 2006 of the respondent, that what were the available remedies available to the applicant. And in that reply, not only did the respondent fail to identify any remedies whatsoever of any nature, let alone deal with their effectiveness, they made the statement manifestly that Armenia's writ does not run in the courts of NKR, and nothing should be said that be taken that they had jurisdiction over that particular territory. It was only until 2007 when, in actual fact, they cited a number of cases which they said revealed the existence of effective remedies. And perhaps I could just ask my learned friend, Ms. Butler, to address the Court on that point.
Mr. President, distinguished members of the Court, it's an honour to appear before you today, and particularly to address the learned judge's question, Judge Albuquerque. I'm very grateful for that question because we're in exactly the same position as he is on this issue. We have searched in vain through all of the many rounds of submissions that have been lodged in this case by the respondent government and found absolutely no mention whatsoever of the two cases on which they now hinge as the very centre point of their arguments on this issue. I mean, we would very much like to also have some details of these two cases in order to satisfy ourselves that they really do relate to Azeris who are from displaced situations. We would simply ask the Court that if time is not given to us to address those particular cases, that the Court themselves approach them with real anxious scrutiny. We note that on previous occasions when the respondent government has relied upon cases from the Armenian judiciary relating to supposed cases of Azeris being able to have their rights redressed and to obtain effective remedies from the Armenian courts, those cases have tended to be slightly misstated. They've not related in all cases to Azeris or to Kurds. One of those three that they've referred to in the past, in their 2007 submissions, actually related to an Iranian man, and none of them at all related to an IDP. These were cases related to very minor, uncontested matters, contract disputes, real estate disputes, employment disputes. There is certainly nothing at all of the kind of sensitive